mortal, and most times death comes when people least expect it. When a person dies without a will, the law regulates his or her estate in the interests of his dependents, the state, and other stakeholders. Our topic today, although a reminder of the frailty of life, also proffers some assurance of order to people even beyond the now. I am Noella Seidu, and this is Law Express. We'll be right back after this break. Do stay with us.
Osea Samoa is a private legal practitioner and a lecturer at the Ghana School of Law. He enjoys playing tennis, spending time with friends, and participating in humanitarian services. Samuel Kwame Ofosu is a private legal practitioner who enjoys sightseeing, watching soccer, and traveling to explore nature. She is a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
As a lawyer, you often hear the question, what are letters of administration? I'm sure you've been hearing every day.
They actually say LA.
LA, yes. Or LA, then, or, yes. So you say, we went to the bank, they said I should bring an LA.
Yeah.
My father died, we went here, what's an LA? So the moment you hear LA or letters of administration, obviously you know that somebody is dead, one, and two, there's no will. Because if the person dies with a will, you know that you will not be applying for LA. Yeah. You'll be applying for probate. You know our system. If you die, everybody's rushing in. It can be very chaotic. So the law, in its wisdom, has put in place that, listen, we have to give the power to one person to, lead what we call the administration, the management of the estate, to distribute it, give aid to that. You are the person who by law, you are entitled to this, I give to you, this person. Yes, so that is letters of administration will basically be the power that the law, gives to one person, confers on one person, one or more person, that's it, because it doesn't necessarily have to be one. You can have up to 4. I'm sure
it's just more common to have one person, really. But then more up to about 4.
More up to about 4. Usually, if it's just one spouse and kids from the same parents, then you have just one person applying for it. Yes. Of course, all interests will be preserved. And you see, the issue is that when we go for letters of administration, it does not necessarily mean that your rights are being determined. It does not mean that you have authority to deal in a property, but you are only administering the property based on what the law provides.
So it's actually a responsibility.
Yes, it's a responsibility.
That is being bestowed on you.
Yeah. So interestingly, you get a lot of people sort of at each other's throat because somebody is going for LA thinking that, and of course there's that misconception that once you take the LA, that means you become the owner of the property.
You understand?
Yes. So as Ami said, it's just for you, to stand in, to give the properties to those they belong to by law. So as you said, it's a responsibility on you and not actually doesn't give you any rights over the properties. In fact, you can get into big trouble if you think that...
You can squander the estate.
Yes, because at any time you can be called on to account and you have to account for every single penny out of the estate.
And another thing is that letters of administration will not be granted to anybody at all. You cannot just go to the court and say that, look, I'm a family member of the deceased, and so grant me letters of administration. No. The law has made provisions. There is an order of priority. So in the instance where there is a surviving spouse, that is the first priority. And then it follows by kids. We have surviving parents.
So when you say priority as to who the court is likely to grant letters of administration to.
Yes, exactly.
Yes. And it also means that the priority means that if you are, for instance, the customary successor.
So an extended family member.
Yes, an extended family member who says, okay, I succeeded him. And the man died with a wife, what we call a surviving spouse, and children.
Yes.
You, the extended family member is coming. You need to explain why they are not part of it or they should be subsidized. Because if we are counting, as you said, order of priority. They come first before you, in order of affairs. They come first before you. So the first person that the law, will look positively on will be the wife. That's what we call the surviving spouse.
You keep saying wife as if it's men who die first all the time.
And that is the challenge.
The jury is out there, but we all know.
You're making women feel guilty, like and uncomfortable.
See,
like
in most just last week I did one with the surviving spouse being a man.
See?
But you do 10, you get one surviving husband.
I wouldn't argue this.
Very well. You know, it's quite straightforward. But in the numbers, although we say that you can be out of 4, what you need to understand is that as administrators, you have to act together at all times. There's nothing like voting. That, okay, we are 3 or 4. 2 says this, 2 says that, no. So the more you are, the more decision-making becomes very difficult. Because if you don't all agree, there's no agreement. Yeah. So as far as possible, you want to keep it to 1 or 2. We all agree, okay, we should do this. But once you have, the law permits, 3, 4. But once you have 4, that means that if this book, we say, okay, we should keep this book here. One says no, then it becomes a problem because you all have to, act
jointly.
Together. Yeah.
And that is why mostly when we apply for early, you see lawyers stating that at the family gathering after the barrier, we have been appointed to apply for the letters of administration, so that it is presumed that probably they have agreed that, okay, the wife and then 1 kid should apply for the early, so that there wouldn't be much confusion as to decision making when it comes to decision making. Let's
rewind the clock quickly, because when lawyers talk, they just go straight under the assumption that everybody knows exactly where it started from and where we are. So you are members of society, and by function of nature, somebody dies. Let's say the man, because you said men always die first. And women, we are happy to live longer. So the man dies, there's a surviving wife, children, probably another wife, a child. What happens next? We all know that normally they will go on a search to see if there's a will somewhere. They might check with the courts within the jurisdiction where the person last lived or might have lived. So if the person lived parts of the time in Accra, they might check the registry here. Of course, it's one high court, but a search will be conducted. Now they realize there's no will. And that now occasions the need or gives the need for the application of letters of administration.
Yes.
How does this process now start?
Okay, so as you said, you talk of letters of administration when you have satisfied yourself that there's no will anywhere, and you do that by, because let me also rewind a bit. Okay. Typically when a will is done, it will be most times done by a lawyer who usually have 3 copies, keep one for to himself, the court deposit 1 in court, and then
give 1 to
the person who did the will. Once you've convinced yourself that there's no will anywhere, by searching through the person's things, by doing searches at the court, and anywhere possible that this could be, then you have to apply for early. The question is, how do you apply for early?
And who?
And of course, that is why lawyers do exist. You can do it on your own, no 2 ways. But the nature of the thing is such that
it's so technical.
You say,
okay. Guided.
So when you come to me and you say you want to do it, and I say, okay, go and file a motion. Will you not ask, lawyer, what's a motion? That's the question. You file an application for early. You still have to ask, what is an application? So yes, ordinarily, you will need a trained person to guide you through these things, because you have, other forms and stuff that you fill. But basically, the law permits you, today by yourself, by bringing an application before the court. Now, in this application, you have to disclose all the properties of the person, the deceased, that's the person who is dead, all the properties that he owned. The law says you should list them.
Yes.
and give their values as close as possible. So, for instance, I mean, your dad had a house in Chado. You have to determine, well, the best if you have evaluation. But if you don't have evaluation, you don't go and you know that, okay, well, a house, a 3-bedroom house.
But you know why this
You won't
valuation
have a
is
fair
done,
idea
right?
of what
For
values.
taxes.
Yes.
Estate tax.
Oh, yes. So the essence of it is that the states, as they do to everybody.
Even after you're dead, you still have to pay tax to the states.
Well,
still need to support
if
the
we
states.
live in that need the money is paying tax. You that is dead, yes, they have to. Yes, so.
Well, you see, before you even state the value of the estate, that is the property of the deceased, when you are going to the court for an order of LA or for the grant of LA, you first need to introduce yourself.
Yeah.
Give details of yourself. So
Your
you,
relationship
your
to the
relationship
deceased.
with the deceased, yes. You so your relationship with the deceased, and then you go ahead to also state when the deceased died, and give proof of that. So with that, you can have a burial certificate or
Death
death certificate or burial permit.
Permits, yes.
Yes, to prove to the court that
You can
indeed the
use
person is
obituary
dead.
notices where
Yes.
where you don't have this.
These days, obituary.
Well, you have to produce evidence to show the court that yes, indeed, the person is dead. And the best evidence is the death certificate, because that was what just like when you are born, you are given a birth certificate.
Yeah.
When you die too, you are given a certificate to show that yes, the person is no more, or a burial permit.
I think
as you
the
said.
situation where an obituary notice might suffice easily is where the person is a prominent person. And the courts can take judicial
The court
notice
can take
of
judicial
the
notice
death.
of it.
Yes.
This is if is this a major state player.
Yeah.
And it's possible the judge
And
probably
then-
was even at the
and-
funeral of
and-
this person.
Of course.
And let me even say this. So today, before I came here, I had a client come to my office, and we were going through some stats and realized that, oh, the mother had some building around Kaneshi, which, you know, it was never transferred because they live inside. And when did your mother die? He said 90-something.
And I'm
That
sure they
becomes
didn't
an
apply
issue.
for early.
They didn't. So now,
Because
in such an instance,
How do you prove the death?
those days, you do not. It's very difficult. And this client who have been, you know, very young, who is now grown over 30 years ago. So in such instances, if you happen to keep an obituary notice somewhere,
It
to
might
show
work.
that yes, you
It
understand.
will work.
But that is
Yes,
if
yes.
there was, because those days I don't think they did those kind of publications widely. It might be advertised on radio, and that's it.
Well, they had their own form of something.
Because my background is from the north, and most of my family is Muslim. Well,
Yeah.
there's no obituary notice.
Which is true.
It's an advert
we-
on
we-
radio, because the funeral is instant. Nobody's taking photos at your funeral. So if you do not have a burial permit, okay, or some death certificate, you are in big trouble. How do you prove death?
But I had a
I don't know if
similar-
witnesses
I
would
think
suffice.
witnesses, and I think we also do add an affidavit of the family head.
Yes.
Yes,
Yes.
yes, yes.
But that is to support the fact that you were selected and the
So-
person died also.
By so if you are bringing witnesses to prove an event that occurred in a family, then I think that the family head is also a prominent person or a key witness who can testify that indeed the person is dead.
Okay.
Oh, that of course, that is, I agree with you.
What even shows is a real family head?
Well, you see, if you are to go into that, then people will be going. But the point is for you to convince the court
Yeah.
that indeed the person
It's dead.
is dead.
And that
You-
is why you come on oath.
Yes.
Because
Yes,
once an
yes.
affidavit,
And-
there are, what's it called? Liabilities for
Yes.
Yes.
Perjury.
Yes.
For lying
And
on oath.
and also, we are probably not there, but because of this, let me jump into the notices. You
And that is
understand?
pasted on
That
there.
is because after you go to court and it's granted, the court will say, go and post the notices at his last known place of abode for 28 days or
Okay.
21 days,
21
depending.
days.
Now, this is because it's to give notice to the whole world for a
Yeah.
number of reasons, one of which we are saying the person might not be dead. You see a notice and say, this person is not dead, somebody. But most often the reason is that people who might not be entitled, you know, will sneak behind and then go. There are times that, especially when you have situations where there are multiple children from, you know,
different women.
one will go and will not list others as beneficiaries. Some will surreptitiously, you know, go and attempt to apply. So when you post it there, and that is to give notice to everybody
who has an interest.
Yes.
Who has an interest,
so
yes.
Once that is seen, then you can come back and say no. There are processes for that.
This notice is done before the actual grant.
Yeah.
This is notice of the grant.
Yes.
Such that you still don't have early. It is after the expiration of the 21-day notice that you can come for the final letters of administration.
And that is where the state will also come in.
Yes.
And demand for their 3%.
So the notice will, be in this form that so and so person has applied to this court to be granted letters of administration. So if you have any reason, it's like the wedding banners that
the bans
that they publish that A and B wants to get married, and if you have any objection,
this is the right
and
time
a similar number of days also, huh?
Yes, 21.
So mostly, so that is talking about proving the death and evidence. That will be at a later stage, and that is not the reason, but to ensure that earlier we mentioned the priorities that you are within your right to, apply for.
Okay, we'll go for a quick commercial break. When we come back, we'll look more into the actual role of the letters, the administrators of an estate upon receipt of the letters, and then tie into pre-grant or pre-application for letters of administration. What is the position of the law in terms of touching the property of the deceased? This is Law Express. Don't go away. We'll be right back.
Before we even go to the duties of the applicants, there is an issue of intermeddling. This is where, before the grant of letters of administration, you see people start using the properties of the deceased without going for the authority from the court to do so. You see people driving the cars, where that's when uncles and then extended relatives will come in to say that, yes, I took the deceased person to school, so I'm entitled to this. So I can enjoy it without anybody's say. But the law makes a provision for it. If you start using the property of the deceased without going to the courts for the grant of the letters of administration, it makes that act is a crime, and that is intermeddling. And the law says that you can be punished by being fined or you go to prison. Yeah. And in addition to that, I think you can be made to render accounts of everything that you've touched since the
person died.
Yes.
But it's important to state, however, that if people were already using those properties during the lifetime of the deceased, for instance, you were all living in the house with the person. You know the house belongs to him. But that is where you all live. You all reside. So assuming the person dies, it doesn't mean that you should all pack out of the house. No. You can continue. But where people pose as if they are now successors, then try to use of, should I say, dissipate the estate. You know the person has a bank account, or maybe you have the person's ATM card. Then you are quietly and secretly withdrawing monies from the bank because the bank still doesn't have notice that that person is dead. Things like that.
And also, you can be called on to account for every penny. If in times you will even be paying interest if it's money that has been with you for a long time. So people must be aware that if you think you're entitled to something, let the court grant you the power before you can start using it, or you can have access to it as your own. Lest you risk, a jail term for something you might not even really, know that is the essence.
Before we went for the break, I asked that we discuss the duties, actual duties of people who have now been granted letters of administration. So you've applied with the support of the entire family. You've been granted letters of administration. What are you supposed to do immediately? What is your actual duty?
Well, as we started, we mentioned it that for you go to the court for letters of administration or LAs for the power to administer. That's why you call it letters of administration. To administer means to deal with it in accordance with law. Yeah. So what you then have to do as an administrator, as you said, is a responsibility. You now have the responsibility to gather the estate put everything together. Now, there are bank accounts scattered all around. You have to now gather everything. This is there. This is not physically to one location, but sort of have an inventory of whatever is there physically, because before, for instance, you are granted letters of administration, if there is money in the bank somewhere, you will not have access to even know the balances in there. So now, with the letters of administration, you're able to write to the bank and say, okay, I now have the letters of administration. Provide me with a bank statement. Let me see how much is in there. You go to Bank B, you can let them transfer the money into one account. You can
but you're making it look
account.
like it's always that you go and then it's a positive bank balance. The person might also owe money.
Well, that is there. So as I was coming to, once you gather it, you are gathering assets and liabilities as well. So after you gather, you have the responsibility to pay off the assets, the liabilities of the person before you come to distribute it in accordance with law.
Okay. Sami, so just debts.
Just as Senior indicated, that when you put all the inventory together, the same way you wish to enjoy, just debts must be paid. So a person, or if there is evidence to show that indeed the deceased owed X amount at the time he died, it is due for payment, you have resources of the deceased, then as an administrator of the estate, you are duty bound to also pay the just debt first before you go to, because at the end of the day, then it's like you need to do the accounts, pay off the debts, and then when there is profit, that is when the residue, that is where you share.
But we forget that the funeral.
Yes.
So sometimes the administrators have to pay for funeral expenses from the estate of the person.
So that was what I was coming to chip in, that examples of the just debts might be the funeral expenses. Sometimes members, family members pre-finance it. There are times you go for loans.
Wow.
People do that nowadays.
It's not a business venture. And the banks
grant loans for just funerals?
It might not be bank loan as such. Maybe friendly loans from other, family members, prominent members of the family and all that. And another one is that we spoke about the estate duty fees, where earlier on we mentioned that the assets of the person, you must put values to it. Yeah. And you mentioned that it's for the taxman to tax it. So yes, you pay a percentage that the court will assess for you as estate duty fees. Now, when this money, is paid, don't forget that by the time you have to pay that, you will not have access to the real funds of the person.
Yeah.
So, as you said, one of them might have to
pre-finance. Because you get it in the course of the application of the grants of letters.
Yes. So that's, and don't forget that, of course, you might have used a lawyer who have charged fees. You understand? Out of it, you pay for filing fees. So these are all just debts that and
of course, pre-existing debts the person might have contracted.
Exactly. So you have people that the person will be owing. The same way that in gathering the estate, there might be people who will be owing the deceased.
And who the deceased also
who owes the hand. So before you do the actual distribution and squander the money, you have to make sure that, yes, he owed this person, he owed this bank loan, this person had his assets, in his custody. You do all those things before, as you said, the residue, the trouble-free one. Then you come to it and deal with it in accordance with law.
Yeah. Great. So now you've paid just debts and all taxes. You have mixed property, so money. There is also landed property, probably other movable property. Way forward.
Okay. So, you see, when you are granted the letters of administration, you don't have the absolute power to determine what goes to who. The law makes provision for that. I think the PNDC law 111
our interstate succession law.
Yes, interstate succession law, which basically guides properties when a person dies without leaving a will. So in that case, the law makes provision. There are percentages that goes to respective people.
Yeah.
That we've mentioned earlier. It includes a spouse, a surviving spouse, children, surviving parents, and then
extended
there is
family
also
or customary successor.
yes, a portion for the extended family. And another thing is that the property or your matrimonial home, the law makes provision that it goes to your wife
And children.
And the kids, yes. And household chattels all goes to the wife.
So
and the kids.
household chattel, we need to explain what that is. So those are cooking utensils.
Cooking utensils, your
wigs.
TV.
Wait, those are your personal effects. Are they
all-
household chattel? I think those are personal effects.
They are personal
I mean-
effects.
I think, broadly speaking, they all go into that basket. You
I
know,
don't think so.
your-
Do you know why? Because of the function of custom.
Okay.
Probably, I'm just saying this because of my unique background.
Yeah.
So up north, your actual clothing and things like that will be distributed also as part of the estate. But mostly that is supervised by the extended family because these are things that you were using personally. But for furniture and beds and stuff like that, I think those are more household chattel. I don't know what your opinion is on this.
So those ones are protected under the law for the kids, and then
For the wife, the spouse,
Why do we keep
or
on
spouses.
saying wife? So spouse, yes.
Well, I mean, it's from experience.
Here we go again.
Yes. So, as Sami was saying, the law makes provision for how, you know, the properties of a person who has died without a will should be shared. So a lot of people come, they are worried, I say, no. It's like mathematics. You can't take
Exactly.
away, it's black and white. So usually I refer you that, listen, go and see it for yourself.
Yeah.
It's there, black and white. What belongs to you, the law has given
You know,
it
the
to
fascinating part is that, for instance, letters of administration are granted. And some people who are interested in the estate, okay, and who have an inheritance therein, insist that perhaps they deserve a greater percentage than other people. It's all in the law. You can't do anything. And if an administrator departs from the law, the administrator will be held liable for that. Because you are bound by duty as somebody holding property in trust. And it doesn't even matter if you are also somebody who can inherit from that estate. To the extent that at this point you're acting as an administrator, you must be fair and go in accordance with the law. So I do not see why people are so usually try to, you know, influence things in that space.
So let me chip in this. Usually you have a control, and this is with the part that goes to the children.
Yes.
As I said it before, when you have multiple children from multiple parents, you know, the law, under the law, it classifies children as one unit.
Yes.
So it doesn't matter if you are from, you know, 3, 4, 5 mothers.
And it doesn't matter your age also.
Yes.
If there's a 2-year-old and a 70-year-old and they are all children or siblings, they all get the same percentage.
You are one unit.
Yeah.
So usually you see a lot of trouble because you have, of course, they are not seeing eye to eye already. And they think that, say no, the percentage that goes to children, if you are 30 children, you share the same thing. If you are one child,
that's all for
it's
that
for
child.
you understand? So it must be clear to you that, well, it's not because there's one surviving spouse and you are 8 children from 4 mothers and you think that, oh, she's taking that bulk and we all have to share this. In the eyes of the law, you are all one, classified as children or child. So your entitlement is the one that goes to the children.
Yes.
You go and deal with it your
So
own
if the
way.
spouse's percentage is higher, okay, so be it. And you know, it's mostly comes to play where, for instance, the surviving spouse has children in the pool. So the understanding is that their mother receives something and then they also will receive something. But that is by operation of the law, because they are very different people. There's nothing that shows that mother's inheritance will be left to those kids.
Exactly.
It is because it's a function of their relationship to the deceased that they are getting this.
So she's getting it because she's a mother.
Or a wife.
Sorry, a wife.
Yes.
Yes. And that is why she's getting it.
Yes, okay. So based on what you said, let's also make it clear that if maybe when I'm 70, 75 years, I decide to marry a 20-year-old woman.
Is that the plan?
No. just for the purposes of the law. Yes. And then I have no child with, this woman. There are 4, 5, 6 other children from 3 other women. And the man passes on. That woman still remains the surviving spouse.
Yes. And it doesn't matter if she married you for 3 weeks.
Yes, once that's married. And then, so the fact of, you do know how our father struggled. And so I tell people then, you go and wake up your father.
And my mother contributed to, his setup and his business.
Bring your father back, let him come and make a will. So, of course, and that is, by the way, that's why we give the advice to people that if you don't want these things to happen, if you do a will, there's nothing like the law will divide it for you. If you do not, then you have no option but to go with what the law has set
largely, if you
down.
have a will, the law might not divide it, but there are exceptions, right?
Yeah, obviously, but you see, that is not the norm. Those are the, the few instances. But of course, you are safe where you are, knowing that, well, largely your wishes will be carried through.
Okay, but we haven't yet talked about vesting of the assets. In fact, I introduced that bit, but then we went ahead. But we sampled people's opinion on the topic. We will take a listen and then we continue with vesting, which is a function of the administration of estates.
Okay.
Administration is a document by the court given to an administrator or someone to look after the estate of a deceased person who hasn't made a will.
Okay, so my understanding of letters of administration will be a court issuing some legal document to someone to be in charge of a deceased who didn't make a will to share his property for wife and family or husband and family. That's my understanding of letters of administration.
Letter of administration is a document issued by the court to an individual to manage the assets or the estate of a deceased person. That is, if the person dies without a will. So we can take it from this angle where my brother dies now without a will. I can go to court and the court can give me a document or the approval to use my brother's property or estate without any interference from anybody.
Letter of administration is simply a legal mandate that is given to an appointed individual to cater for estates or properties of a person who died without a will or someone who died intestate. This particular law is given its power in the PNDCL 111 or the Probate and Administration of Estates Law 1985. So when this particular power is given to the individual, it gives the individual the chance or the opportunity or the legal bearing to cater for the estate and properties of this person who couldn't make a will before dying.
It's interesting, huh?
Yes. There are some few notes. The first is that the term is letters of administration. Okay. You hear people saying letter of administration. And also that there is one person who commented that it's a document that is given to an individual to look after the property of a deceased.
Straight up.
Yes, you are to distribute. You are to manage the estate of a deceased. So it is not as though once the grant of the letters of administration is given you, now you have rights in it. You can do anything you want to know. That is not it. You are duty bound, and those duties are set out in the law. That once it is granted to you, distribute it in accordance with law.
I think generally they got a sense of what it is.
Yes.
Some things stand out. They all know that, look, it is a process that has to do with the administration of the estate of somebody who has actually died. They all know that if somebody doesn't die, then it doesn't become something to be discussed. Yes. The challenge is the actual role of people who have been given this responsibility. And this is a great justification for this show.
And another one is who to apply.
Yes.
I heard one of them commented that if my brother dies. So now it takes us back to the priorities as to who the court will grant letters of administration to.
Yes.
Yes, if your brother dies and you are named as a customary successor, then you find your name in there. If not, if there is a surviving spouse,
Parents,
children,
Yeah.
then you cannot go and apply as of rights that
Yeah.
because the person is my brother, I'm applying. You know. Those are some of the misconceptions we have out there.
Before we went over for Vox Pop, we were discussing the distribution, actual distribution.
Yes.
You've done what is required of you as an administrator. You have paid all the just debts. You have, you've literally, gathered the estate. Now you've paid the taxes, and it's time to give to the people who have been listed by the law as the people who should benefit from this estate. How do you move forward? I talked about mixed property, where you have money, you have movable property like cars and other things. You already discussed the issue of household chattel. Now it's the point of the landed property and other things.
Okay, so let me say this, that the whole essence of the distribution is to give legal ownership, to the beneficiaries. Because apart from that, how do you show that, okay, yes, I inherited it, this is mine?
Yes.
Is by, giving you legal ownership of it. And where this legal ownership passes is by what we call a vesting assent. So if you have any
landed property
that has title, like cars that, so for instance, let me even take cars before I come to you.
Houses,
so you realize that if I have a car and I'm selling it to you, I sign my Form C. To you, you go and register. Now the person whose name it is dead. Now the LA gives the administrator the power to sign that document, which you, if you are the beneficiary, you take it to DVLA to register it in your name.
Great. So technically, the LA operates as a power of attorney by the dead person, giving you limited scope to deal with his or her property.
That is it. So you sort of stand in his stead.
Yes.
And then do the distribution as if he was alive. And you are saying that, okay, I'm giving you this.
Yeah.
How do you give it to me? What document do you give me, to
Because the danger
that?
is that, for instance, as you rightly said about a car, assuming you now start driving the car, yes, it's been distributed, but until it's vested in you in some form and you have all the paperwork done, if you also decide to sell it, how do you now sign it off? If you decide to re-register the car, what do you do?
If you decide to
if you are even to
insurance.
prove, no, I mean insurance, a driver can insure in his own right. A third party who is not owner but who drives the car can insure. But we are looking at where you want to probably prove ownership. For instance, it's a dead person's name that is on the document. How do you do that?
Yes, so that is the point I mentioned about vesting assets. So what you do is that you prepare this document that lawyers or the law called vesting asset, because it's vesting it in somebody's name. So the same thing is used for land, houses, whatever. I think you can show with some document that, okay, this is mine. You do that by signing the administrator signing this vesting assent into the name of the person, who is the beneficiary not anybody, in accordance with the law that we keep mentioning.
Yes.
So if the law says that, okay, if there's one house, it belongs to the surviving spouse and children.
Yes.
Then you vest it
in them,
in the
jointly.
name, in their names.
Yes.
Understand? If this car under the law should go to you, then you sign the vesting assent into that person's name. So with that document, that is what you use to prove that, hey, from today onwards, I own a car.
Yes.
Yes, because it's been vested in you. Otherwise, what shows? So yes, how you transfer the property of a disease is through this vesting assent that we talk about.
It's important at this point to also add that where there is more than one administrator and they finally come to the point of vesting, they all have to sign jointly. Like you said earlier, they need to, at every point in time, act together. So even in vesting, they all have to sign. Yes. So one administrator cannot vest you.
No.
So if there are two joint administrators, they both have to do this together at the same time. If not, it is an invalid vesting.
That is correct. And let me also add that, so like you mentioned that landed properties and all. So when it is vested, you can take this vesting assent to whatever registration body it is to transfer it into your name. So if you had a land title certificate in the name of the deceased, and this vesting assent is vested or is signed onto you, you can take it to lands and they will register it.
Well, sometimes they may require the LA just to confirm that the people that vested are the real people. Sometimes they want copies of LA attached to support the authority they had to vest in you. So, but this is just the process. So if it's DVLA, if it's lands registry, lands commission, it's the same process. You take the documents, and once they are satisfied that this is a valid transaction, to be transferred into your name. And it's safe to do it early in the day, because if you fail to vest in yourself and then you die, it becomes a conundrum for your successors also, because the property hasn't passed into your name. So we have some questions coming in by way of social media. Let's attempt to answer them, although it will be limited, considering that it's just a few paragraphs that we have to work with no opportunity to ask follow-up questions.
My husband died last week. His brothers have asked that we apply for letters of administration. It has only been 8 days since he died, and we have not even observed the 1 week ceremony. I am the second wife and feel it is too early. Can I stop the process? He has not even been buried.
Wow.
Well, so 8 days after death, they want to apply for early. Well, so technically, once the person is dead, he's dead. The law doesn't give a timeline before which you can, apply for earlies. But you see, we also operate in a cultural context. So if you are talking about the law properly so-called, there's no time limit. The other one is our customary and cultural content that you want to look at, so people not to say, well, you even killed the person because of the property. See, the person has not even been buried, and yet you are running over to go for LA to distribute, the person's properties. So yes, it might be a bit odd, but when you come to the strict sense of the word, nothing stops it. You cannot go to court for an injunction to stop that. No, but you might want to look at the cultural settings under which you operate to say that it's too early in the day. Too early in the day.
But shouldn't you be mourning the death, after 8 days, and then it will seem like you are more focused on the properties of the
some
person.
people believe in the fact that they say, let the dead bury their dead and mourn their dead. So,
but I think if need be, if there are circumstances that justify that you have to immediately go for early, if there are kids' school fees to be paid,
perishable stuff owned by this person.
Yes, nobody is willing to foot for those bills, and you know that there are enough funds in the person's. I think there are some, you can apply for it.
This is a moral problem.
Yes.
Emotional problem.
Yes.
Okay. You are lucky they are looking for letters of administration to start with. Clearly, if there was cohesion in this family, you won't even be worried and asking us this. It means that there's a breakdown in communication in a way that you don't get along, and then you're exploring legal opportunities to be able to, stop the application. In the strict sense, like Peter said, even a day after the person dies, if that is what the family has agreed to do, so be it. There's no law anywhere that says that you need to wait for the burial of the deceased before you do that. Although, in order not to offend the sensibility of people in the grief process, normally people want to wait a little so that they try to at least attempt recovery before they carry on and pick up the pieces. In this particular situation, it's even the brothers that are calling for this. When you look at the priority of grant of letters of administration, unless they are the customary successes, even at that, they will be at the bottom of the list in the priority list. It means that you as a surviving wife is more likely to be granted ahead of them. So we are looking at all these things, we still, like I said, do not have any opportunity to ask what the special circumstances might be to warrant this. Perhaps this was just a wicked guy and they've decided that we are not going to spend time grieving him. We will just try to see if we can get his property, to do his funeral quickly and move on with our lives. So you can never tell, but legally, there is nothing wrong with the suggestion they are bringing there. The only option is probably to sit with them and try to get them to understand that it's too early. If the rest of the family support and you are in a minority, they would apply for early, and it's better you play along. If not, you'll be kicked out of the process and you have a tall order challenge in it. This is how I view the situation. Instances where, other instances where LAs may be applied for beyond what we've discussed. So for instance, you make a will and you put in executors. I know today we are not discussing probate, we're not discussing wills. We already did that in prior episodes. So let's say somebody prepared a will and put in an executor, which is the people they've listed that should they die, these are the people who should distribute my estate. Now, these executors die ahead of the testator, the one who prepared the will or made the will. And the person doesn't come around to fixing it. Or they even die together in the same incident. Now, the estate is there. Somebody has to administer it. But then the people who were selected by the deceased are gone. What should the beneficiaries do in this situation?
Okay, well, as you said it, let me repeat what you said. That first of all, when we talk of early, we stated that it means there was no will.
Yeah.
But these are instances where, although there was a will, the law still permits you to apply for early.
As if the estate fell into intestacy.
Yes, and like you said, well, you appoint somebody you trust to stand in for you, who we call the executor under your will. Unfortunately, by the time you die, because don't forget that wills are opened after your death.
Yeah.
By the time you die, we realize that the executor is no more. So the beneficiaries now, because they were not named as executors, cannot apply to call for probate.
Yeah.
So now the same priority list, or the beneficiaries can apply for what you call LA with will attached. So yes, you apply for LA, but you realize that we said that in applying for LA, you put an inventory of the person's properties with their values. Now you have a will which already has
the list
of him. So you attach the will, and then don't forget that with the will attached, the administrator is now still going to share it by the will.
Yes.
And not you know,
law.
as if he didn't make a will.
So that application for LA with will attached, okay, is just to stand in as the executor.
That is it. That is it.
But you are not called an executor. You are an administrator empowered by letters of administration to execute the terms in the will or the provisions of the will.
As instructed by the testator.
Yes.
So
Yes.
everything listed by the testator will go to the beneficiaries as named.
Yeah.
Yes. So that it is not as though because you have gone for an LA with will annexed, you'll be applying the
PNDC law 111. Yeah.
No, you go.
And also to help you vest. Because yes, they can say we went for the reading of the will, we heard who owns what.
Yes.
But now who is going to give it to us?
That is
So that is the reason
so
why.
that gives you the power.
Yes.
And let me also add that it's not only in instances that the executor predeceases
The testator.
that this can happen. I have a live instance where and it happens. So this is an interesting story where there was a will, and then the man appointed one of his siblings from the family side as the executor. He dies, they read the will and find out that everything in the will is given to the man's wife and the children. Nothing goes to the family. Of course, the family is aggrieved. The executor is part of the family.
Yeah.
So he's not too aggrieved, but he doesn't also want to incur the displeasure of the family,
rest
because
of
he
the
said,
family,
look, once you go, that means you are with them.
Yeah.
Now the man is refusing to apply for probate. So then you go through some processes for him, what we call renunciation of probate or refusal. So it becomes clear.
Well, if somebody serves notice for the person to apply for probate and he fails to show up also,
That is
by
it,
operation of law, it's deemed that you've renounced probate.
you've renounced him. So in that instance, then the beneficiaries now can also apply for
In the order of priority,
yeah,
as
early
provided
with
for by the
will
law.
attached. Yeah, so those are some of the limited instances
Where
where
Ellis come.
although you have a will,
Yes.
you might need Ellis.
Great.
I'm surprised
You know-
the family members are aggrieved that they did not get anything, because once a person makes a will, there is no duty bound on the person to give you anything. The testator will be distributing his property.
Because I mean, it happens every day. The family is always aggrieved.
So I think they should understand that
It's the dead person's
the
wish.
last wish,
Yeah.
that we have to respect it.
See, the assumption is that probably somebody had confused the testator at the time that will was made.
Yes.
Some people even go to the extent of saying the will is fake
Yes.
because what they expected is not what they see. There are times where even it's still to wife and children, but some children are given more than others, and that alone can bring a whole new storm. So wills, and it's shocking that people will be fighting over property of deceased people as if it's their right. Like, you haven't worked for anything in somebody else's estate.
But they have legitimate
That person
expectation.
owns his property. He or she is dying and says, this is who I want to give it to. Or, I don't want to deal with it, I want the state to distribute it. Then you sit somewhere and you think that you deserve more, as if you've paid for shares and you have a stake in it. But that is how life works, right? I mean,
from where we sit, we see terrible things.
yeah, I mean, you
mean,
must be a failure to make your life revolve around somebody, a deceased person's property. Because if you really work hard, how did that person acquire that? By hard work. You should be able to do that for yourself, rather than sit aloof and wait for somebody else to die, a misfortune to now benefit from same. It's been an interesting conversation, huh?
It has.
But it's like we just scratched the surface. Because when it comes to matters on administration of estate, like it's a whole big, process with different complications and different branches to it. There's no way we could ever fully exhaust this discussion. But the idea of the show is to keep the conversation going so our viewers can talk to lawyers, can talk to other people who have knowledge on the subject matter to at least explain further whether they have rights, what they can do as caveators, because some things like that we never even touched today.
Yes, like the caveats, yes. We never touched on that, but
yes,
I think
that is a whole complication, and it was quite intentional that we didn't draw that in.
I mean, that is true. There are a lot of areas, a lot of technicalities that, as you said, I mean, this is just an introduction to the topic, and then to keep the conversation going. But this is never an exhaustive discussion on...
No. Perhaps we can have another conversation on caveats.
Yes, we can.
Generally.
You know that, lastly, even if you fall within the order of priority,
yes,
there can be instances that will exclude you.
Yes.
So you can say, yes, I'm a wife, but due to a peculiar nature, you can be of unsound mind.
Yeah. Probably you're not fit
are
enough
not
to
fit enough.
administer the estate.
Those circumstances are exceptions that even though you think that you are in the order of priority,
or you don't even have the capacity. Maybe you have a sight problem.
You cannot.
Yes, and so it becomes almost impossible to read through the documents, go to cite the things and organize them. You have a challenge with even reading and writing in a way that, look, if the next person who is a child can do that, why not?
Why not?
Because at the end of the day, there's a law that dictates the percentages and the fractions that go to anybody. So that cannot be changed. It's just a responsibility at this point.
Just an oversight to ensure that everything is done well.
Yeah.
Yes.
I think it's a great point to conclude our conversation. It's been great having you two gentlemen on the show. Thank you so much. Viewers, my name is Noella Seidu. I was joined by Peter Osei Samoa and Samuel Kwame Ofosu. This has been our show. Goodbye.